Okay, it says it's now streaming. Perfect. Well, good morning again, y'all. This is the State and Local Government Committee's Subcommittee on Discontinued Roads. My name is Ann Matlack. I chair the State and Local Government Committee, and I'm here today with several members of our committee and some invited guests who will help us understand what the issues are with concerning discontinued roads. We also have our OPLA analyst, Lynn Caswell, who will do a lot of the providing of information in a more legal format. So again, my name is Ann Matlack. I represent House District 92, which includes the municipalities of Cushing, Thomaston, St. George, South Thomaston, Matinicus, Cree Haven, and the Muscle Ridge Islands. And if I could get the other committee members to introduce themselves, Representative Toole.
Thank you, Madam Chair. I'm Representative Will Toole. I currently represent the towns of Cutler, East Machias, Eastport, Lubec, Machias, Machiasport, Brook Bluff, Whiting, and Trescott.
Thank you. Representative Downs.
Good morning, everyone. Representative Kathy Downs. I represent District 130, which is Bucksport and Arlington at the present. And looking forward to today. I'm glad to see everybody. Thank you.
You're welcome. Representative Copeland.
Thank you, Madam Chair. My name is Lynn Copeland. I'm honored to represent the folks in Saco, currently downtown and coastal.
Wonderful. And Senator Claxton.
Good morning, everyone. My name is Ned Claxton. I have the honor of representing the folks in Auburn, where I live, Senate District 20, in addition to Mechanic Falls, Minot, Poland, and New Gloucester.
Thank you. I think we'll get going, and we will have Lynn go over the legal principles with regard to this. I should point out we also have Roberta Manter of Maine Roadways, Tom Doak of Maine Woodland Owners Association, and Rebecca Graham from the Maine Municipal Association, who'll be presenting information a little bit later on. So Lynn, if you'd like to kick it off for us, if you could give us the background on this subcommittee, I'd appreciate that.
Thank you, Madam Chair. And I'm going to start with a caveat. I know I am not going to share everything that you need to know. This, as I always say, is a complicated topic. I'm going to identify what I think are the basics that hopefully will help you. And then I fully expect you to be asking me questions that I will need to provide more information on. And so I thought I'd start with just what LD 1513 proposed for the committee, just to remind everyone what the committee is got going on. And I'm just going to also remind everyone that I am working from home and I have cats. So you may have just seen one flashing across the screen. So LD 1513 proposes to make two changes in statute. It's, I think, the testimony from Maine Roadways and the Maine Realtors Association and the other property owners who testified in favor of this bill and the sponsor talked about the burden that property owners who live on discontinued roads that have public easements. There's a burden and responsibility that is placed on them, and that can be that can cause problems due to the use of the public easement. And there can be some costs incurred to those property owners when a municipality discontinues a road and retains a public easement. So what this bill attempts or proposes to do is to require municipalities, if it's a discontinued road with a public easement, and it is that discontinued road is the only means of access to one or more residences, then the municipality has an obligation to provide sufficient maintenance to keep the road or way passable to access those residences. So you'll recall that when it comes to a road that a municipality is responsible for, the standard on the municipality is keep it opened and kept in repair so as to be safe and convenient for travelers. So that's the responsible, safe and convenient for travelers on a road. This is saying on a discontinued road with a public easement, and that road's the only access to one or more residences. They don't have to keep it opened and repair so as to be safe and convenient. They have to provide sufficient maintenance to keep the road or way passable to those residences. So it's a different standard, but it is an obligation which would be placed on a municipality. The other proposed proposal in this bill is to allow those property owners to petition the county commissioners should they feel that the municipality is not living up to that obligation of sufficient maintenance. Now, the statute currently allows 3 or more responsible parties, which is an odd phrase, but I would say, think about the current statute allows 3 or more property owners, residents in a town, people who use a road. Currently, individuals can petition the county commissioners if they believe a municipality isn't keeping a road safe and convenient. And the county commissioners can then look into it. They can order the town to do a certain type of repair. They can set a timeline on the town for when those repairs must be done, and they can award costs to those people who petition. So similar to the existing process, the proposal in 1513 would allow 1 or more of those residential property owners on a discontinued road to petition the county commissioners should they feel that the municipality isn't living up to its obligation to keep the road, to provide sufficient maintenance. That is what I can gather from LD 1513. That is clear to me that that's what LD 1513 is trying to do. I'm a little dyslexic with numbers. There's other words in this statute that may actually be trying to do more. We didn't have an in-depth discussion during the public hearing or the work session. At least I couldn't recall it. If it's intending to do more and the committee is moving forward with this bill as drafted, or the subcommittee, we can have a further discussion on some of the words that are in the statute. But I do want to just point out, I forgot to mention that that requirement to provide sufficient maintenance is a standard that's determined by the county commissioners. So in this bill, the county commissioners determine that standard. And I believe that was part of MMA's testimony, pointing out that role of the county commissioners under the proposal. So that is, in a nutshell, what 1513 proposed to the committee. Now I'm going to switch to a little bit of a overview of the law as it may or may not apply to what you want to do. So you'll recall, those of you who've been on a roads committee before, which are all of the interested parties, they have been MMA, Maine Woodland Associates, and Maine Roadways have participated in numerous committees, subcommittees, commissions, and studies. They have been going on for years. I posted a report from 2013 on this subcommittee's webpage. There was a report in the 129th that had to do with ATV trails that mentioned this whole issue of discontinued roads and public easements. There has been proposed legislation in every session for many, many years. So I'd like to just point out what the legislature has accomplished to help solve the many problems that arise with discontinued and abandoned roads. So you'll recall that you all, the committee, state and local, and the 130th passed, the legislature enacted, and on October 18th of this year, there is a new law on abandonment. So there was a new process that this committee actually was developed from a subcommittee in the 129th that is now going to be law, and that changes the abandonment statute, the process involved. And with respect to what you're going to be talking about most likely going to be talking about in this subcommittee, it did specify the scope of the public easement that a municipality would retain. So I've said before, and I'll discuss a little bit later, that the scope of the public easement that a municipality retains when it discontinues or abandons is not clearly defined in statute. Defining it in statute retroactively has been discussed and generally considered to most likely result in an enormous amount of unintended consequences that that nobody can really foresee, right? So you all define the public easement moving forward for abandonment. In 2018, the legislature changed the law with respect to discontinuation. And part of that process, that was the change that was made, is it limited the situations where a public easement would be needed when a road is discontinued. So public easement is often needed when a road is discontinued so that all the property owners can get access to their property. Because you'll recall, when a road is discontinued, the legal title to the property, that road, goes to the abutting property owners to the middle of the line. So if, you know, neighbor A and B own the road and I'm neighbor C down the way, I can't go across their property, right, to get to my land unless they let me. If there's a public easement, I have the right to cross that property to get to my house. So, and that's often why a public easement is needed and was retained when roads were discontinued and abandoned. So 2018 discontinuation statute now says property owners have 1 year before the road is discontinued to try and execute private easements among themselves so that everyone can get access to their property. If that happens, the municipality then discontinues the road without a public easement. So then those property owners don't have to worry that the public use will somehow cause damage to their road. If the property owners do not come to the necessary agreements to provide access, then the municipality has the ability to retain a public easement. Another bill that actually just went into effect in June of this year came out of the judiciary. There was a new law about cost sharing among those owners along private roads. A little bit different, but not really. And so the new law out of judiciary requires a cost sharing for the maintenance if there's not already some sort of agreement or requirement on property owners. In 2015, I believe that's the year, there was a change to the law that made it a crime, Class E crime, to damage or destroy a road on a public easement due to the operation of a motor vehicle. And you'll recall people have discussed how useful that is as a tool, but it is now a crime. And every time I look into and talk to people about roads, I learn something new. I learned something new last night about who can enforce that law, but I'm not going to tell you that because I know I'll get it wrong. But it's not just police. That's what I learned, and maybe Tom Doak will illuminate that a little bit more. Other laws that I think you might be interested in is there is a law that allows municipalities to use their equipment on private ways, which is the same as public easements, if it's in the best interest for fire and protection. And we talked a lot about that constitutional balance when we talked about the Wyndham bill, about striking a balance. When can you use public funds for roads that are not public roads? And so there is a statute that allows it on private ways or public easements for fire and protection. But again, that what that allows is and when that can be used is up to the municipalities. So those are some of the statutes that have been enacted over the last few years. And I guess I want to, oh, one I forgot, I'm sorry, one I forgot is both residential and non-residential property owners, when they sell their property, have an obligation now to disclose the ownership of the road and the maintenance. Now, that's not exactly what the words in the statute say, but primarily the disclosure is to put people on notice if they are buying a piece of land that is on a discontinued road, whether it has a road maintenance agreement, whether the municipality is responsible. And those were recent changes, one came out of state and local and one came out of judiciary, that apply to both residential and non-residential land purchases. And I know that there's a whole bunch of other random laws that may be relevant that I haven't raised. And hopefully they'll either come to my mind or you'll ask questions about it. But I do want to just spend the last few minutes talking about the public easement. So as I said previously, what the scope of the public easement is really unclear. What's also unclear, and you've probably heard this, is whether or not a public easement exists on a particular discontinued or abandoned road is also sometimes hard to determine, because over the years, the law has changed. Prior to 1965, if a road was discontinued, technically a municipality had no legal right to retain a public easement. However, it has been stated by scholars, people who study public easements, that some municipalities retained a public easement even if they didn't legally have the authority. After 1965, I believe the law was that a public easement was retained unless the municipality specifically said otherwise. And there have been stories where a municipality really didn't realize they were keeping a public easement. That wasn't kind of part of their process, but one attached. And as I said, the law moving forward with respect to abandonment is specific, but that's only starting since October of this year. And whether or not a public easement is kept for discontinuation changed in 2018. So it has to be fairly specific. But basically, it's anyone's guess in many situations whether a road was actually discontinued or abandoned, because you need to find the records. Sometimes they don't exist. Or the records of whether the municipality deliberately, intentionally kept a public easement, didn't keep a public easement. And that is a complicating factor that I'm not sure I'm not sure how that's resolved unless you wave a magic wand and say every discontinued and abandoned road in the entire state has X. And again, that's going back and changing legal status in maybe thousands of situations, I don't know, and enormous unintended consequences. So you're going to have to proceed carefully in trying to unravel that and how to solve that problem, which is really the problem that keeps coming back. And that is the public easement use, because it's a bit undefined, can in certain circumstances cause damage to a road or just wear and tear that the property owners are responsible for. And the tension is who should pay for that. And the municipalities will say that they have made a decision on whether or not a road should be maintained. They have financial restrictions. It's a balancing, decision on their that they have made, it's a tension between the property rights and the interests of the municipality, the taxpayers, and that's another complicating factor on top. So I think I've hit the highlights of what I wanted to say. let me just look at my notes to make sure I haven't forgotten anything. I think I've hit the highlights of what I could identify that you may find useful. I guess I want to ask the committee if there's anything specific that I didn't address that you'd like me to spend a brief amount of time on.
Do any of the committee members have questions? Senator Claxton.
Is passable defined in statute?
It is not. The proposal in 1513 has a few areas where I would recommend more discussion. Passable is not defined. However, the proposal says the county commissioners determine that what is passable and what is that required sufficient maintenance.
Thank you.
Any further questions from committee members? I think that we can continue on. Lynn, I guess we can move on. We can move on to our guest now. All right.
Yes.
Thank you. Thank you very much for that. That's a lot of information. We have 3 invited guests who have expertise in this area. They have many years of experience dealing with these issues. So we thought these might be the people to help us clarify what this bill is about and potentially wrap our arms around what discontinuance in public easement means. So first we have Roberta Manter from Maine Roadways. Ms. Manter, good morning and welcome to our subcommittee. You're a frequent flyer in these areas, so I look to you for information here.
Thank you for letting me speak. It's been a long haul for us. My husband has been on this road for 50 years. I've been here for 40 years, and we've had problems with it since day one. My problem here today is that I'm trying to figure out how to condense 50 years of frustration and the concerns of people all the way across the state. Literally, we have people from one end of the state to the other who get in touch with me with problems for these roads. So I thought the first thing I would do is to go down what you already have. I looked the other day at the materials that have been posted for the subcommittee. You already have David's testimony regarding the Constitution and many ways that his constitutional rights and the rights of those across the state have been violated under the current laws. You also have more testimony from him that he just put in recently, going through his history on this road and specifically how his constitutional rights have been violated here. You have my testimony explaining the bill that I put in originally, and more testimony from me rebutting what Maine Municipal Association had said. You have the report from the stakeholder group a number of years ago, which Ms. Caswell mentioned. They did an excellent job. They spent a lot of time on it, going into all the details and what could possibly be done to solve some of the issues. And that has some excellent ideas in it, which unfortunately didn't get passed. I just sent in a copy of the New York minimum maintenance bill, which unfortunately did not pass, but we thought it was very well written and might be used as a guideline for some possible solutions. And I gathered that even though the law didn't pass, there are some towns that are doing it anyway in New York, and there are several other states that have minimum maintenance statutes. You also have testimony from various people across the state that are having problems with these roads. There would have been more, but I know of at least 2 people who have actually died while waiting for this to get resolved. Perry Lamb was an advocate from way back when we first started trying to get legislation. And he went through 2 lawsuits as a pro se litigant. He fought diligently for years until it came to the point where he was in his 90s and couldn't fight any longer. And as I said, he finally died without ever seeing it resolved. I heard from another person who said, please don't get in touch with us again. My husband is sitting on the porch dying with cancer with the tears rolling down his cheeks, watching loggers destroy the road that he built. There are also a number of people who have cut their losses and moved elsewhere because they just couldn't cope with it anymore. And for their own physical and mental health, they had to just cut their losses and leave. There are also a number of people that have been in touch with me who have said, I'm not going to submit testimony because I have lost hope of the legislature ever doing anything that's going to really help. So, as I said, there would be a lot more testimony, but there are people in those categories who are not submitting anything. We're not asking for you to pass any ex post facto law. We realize that that's problematic for a number of reasons. The prime one, in our opinion, is that the Constitution says you can't do that. You cannot pass ex post facto law. So we're not asking you to do that. I thought it might be helpful to go down through some of the components of the problem. First of all, we don't know what we have. As Ms. Caswell said, lots of times the records are difficult to find. Lots of times it's unclear exactly what was done or under which statute because the statutes have changed. And this is where it's getting to be, and sometimes almost a full-time job for me, responding to people's requests for help trying to figure out what the legal status of their road is, going back through the records and trying to find it, and then trying to explain to them what the records mean. Another problem is that towns need to cut their costs. We realize that. The price of building and maintaining roads has skyrocketed in recent years, due largely to increased traffic, increased weight of vehicles going over the roads. I remember a few years ago testimonying against a bill that would have allowed even larger log trucks on our roads. And the DOT also testified against it because the cost of maintaining these roads can be just phenomenal, especially where there's a road that has not been kept up with and it's been allowed to deteriorate, and then someone wants it fixed back up again. So that's a problem that needs to be addressed. On the other hand, landowners do need access, and if they're going to be allowed by the town with a building permit to build on these roads, if they're going to be taxed then for having a residence on the road, they should be able to get to that residence. Rights and responsibilities need to go together. If a town wants to have the right to use a road freely any way they want, any time of year, then there's some responsibility that needs to go along with that. They shouldn't be just being able to use the road and having no responsibility for what they leave behind. The people who actually have property on these roads have a stake in what they leave behind. If they ruin their own road, they can't get to their own property. But someone from across town or even from out of state can come in during mud season and say, oh, look, here's a good place to go mud running, and just tear it up and leave because they don't care what they left behind. There's also the question of the constitutional issues. And as I said, my husband went into great detail on that, so I'm not going to take extra time to do that here. There's also tax inequity. In a lot of cases, towns charge the same amount for taxes for a person on a discontinued road as they do on a fully publicly maintained town road. In some cases, they even charge people more because they have privacy, and that's seen as being a value to the property. But they're not taking into account all the money that these people are having to pour into the road to keep it usable for themselves in the face of public use. That's one way that this could be attacked, is to put some limits on what can be taxed for a person on a discontinued road that's a public easement, or possibly some reimbursement for the money they have put into the road. Liability of private repairs. In a lot of cases, these people are maintaining the road any way they can. They may be doing it with unregistered motor vehicles. In one case, we knew of someone who was plowing his road with a sheet of plywood strapped to the front of his Jeep. And, you know, they're just doing what they have to do to try to keep the road passable so they can get in and out. So what happens when they're going one direction with a plow and they meet somebody coming headlong the other direction with a snowmobile or a vehicle of any kind? Who's going to be liable if there's an accident? And there's also the question of if someone has tried to do maintenance on the road, but it isn't perfect, they've done what they can, but somebody, because of the condition of the road, goes off into a ditch or hits a bump, damages their vehicle somehow, who is liable for that? In our case, we were actually sued because someone claimed that he had damaged his vehicle driving through a ditch, which he said he didn't see, but he'd already been down over a road that looks like a dry brook bed. So who knows where he actually damaged it? There's also a big problem with poor or unequal enforcement of the current laws. The law that we have about damaging a public easement with a motor vehicle being a Class E crime, I've had several people that have tried to get that law enforced, and law enforcement comes out, looks at the road and says, sorry, there's nothing we can do for one reason or another. And so their problem persists. I have one person who tried to get it enforced through the Forest Service. And last I heard, she had submitted them a 1/4 inch thick packet of evidence, and not a whole lot had happened. They had gotten the logger to come back in and do some work on the road, but he had not put it back in the condition that it was originally. And I don't know whether anything has happened since then on that one. Also, as far as unequal enforcement goes, my husband actually spent 8 days in jail for, quote, obstructing a public easement. His obstruction consisted of putting up a couple of no trespassing signs and standing in the road and telling somebody that he didn't want them using it. And the judge said that even if he had put a no trespassing sign along the side of the road, that would still give the public the impression that they shouldn't be using the road, and therefore that constituted an obstruction. On the other hand, we have someone in the town of Paris who has spent time in jail for supposedly trespassing on a road that is in exactly the same legal status as ours. And the person who assaulted him for walking the road basically got off on a plea bargain. They were not charged with obstructing the road, even though they have 2 locked gates on the road and have parked vehicles on the road. If we did anything like that on our road, my husband would be back in jail again. So there's very unequal enforcement, partly because people just don't understand the law. And in order to get it through court can be phenomenally expensive. And so a lot of these matters don't get the resolution that they deserve because there just isn't something available to the common person who doesn't have a lot of money to fight it. Going down through some possible solutions, Vermont had a law passed several years ago that required all towns to do a comprehensive inventory of every road that they had, or any road that they ever had. And they were given a certain amount of time to do this inventory. Then they were given some more time to decipher what the status of each of these roads was. And the classifications went all the way down from fully public roads down through what they call a trail. And a trail in Vermont is basically the same thing as a public easement is here in Maine. And I have a friend who lives in Vermont on one of these trails, and she has exactly the same problems that we have with public easements. There's property in beyond them that's forested, and they've had loggers come in and use the road until they chewed it up to the point where they could no longer use the road, at which point they started using her lawn to drive around the bad spot. So this is the kind of thing that we see here on public easements. I think doing an inventory would be an excellent idea, but then the problem after that is what do you do with these roads once you've figured out what they are? I made a suggestion once a number of years ago. This was brought up before the legislature that should towns be required to do an inventory. And at the time, Maine Municipal said this was going to be a horrendous task for the towns, that sometimes the records have been lost. In many cases, we find that town offices had a fire and the records just aren't there anymore. And this was going to be terribly expensive for towns to do the research. My answer to that was that each town, with its tax bill to save an extra mailing, could mail out a list of the roads they know they have, which is easy to find because they're required to report it with the DOT every year in order to get local road assistance program funding. And Pete Coughlin from the DOT was present at that hearing, and the legislators asked him if how long it would take for the DOT to come up with these records if any town asked for them. And he said, if I remember right, about 10 seconds. And then they asked him if it would be a problem if all 400 some odd towns asked the DOT for that information at the same time. And he said, no, that would not be a problem. So my proposal was get that information first, put it out to the townspeople. These are the roads we recognize, and tell them if there is any road that you think should be on this list and isn't, you have a certain amount of time in which to bring it to the town's attention. And if it appears that, oh, it was just an error, you're correct, that should have been on the list, then that's taken care of. If it's a road that they think should not be on the list and someone is disputing that, then they would need to have, notify all the abutters on the road and have a public hearing and determine what's going to be done with that road. Any road that has not been presented for review within a certain period of time would be presumed to be discontinued. So that would be one way to shortcut the process of trying to identify all these roads. Another way of cutting costs for the town is the minimum maintenance road. And I said New York had a very good bill presented, which I've submitted for you to look at. In a lot of states, towns are not allowed to discontinue a road if there is any resident on it. In a lot of states, they are only allowed to discontinue a road if the petition is presented to them by the landowners on the road requesting to have it discontinued. In one case, they're only allowed to discontinue the last 1,000 feet of a road, and then only with the consent of landowners. So these are the way some other states manage the situation. Here in Maine, discontinuing a road goes to a vote of the townspeople. Now, if you have, say, even 10 people living on a road that the rest of the town doesn't use, and the rest of the town says, well, look, we don't need that road. We could cut taxes by not doing the repairs that these people are requesting. How much chance do those 10 people have of outvoting the rest of the town in order to get their road to not be discontinued? And yet in other states, if anyone on the road objected to the discontinuance, it would not be allowed. So shame on Maine for allowing that. Access, other states prioritize private access over public access. This is something that's been argued over in Maine for quite some time, that when you discontinue a road, which was originally taken as an easement over the ground rather than taken in fee simple, that when the road is discontinued, that land has to go back to the abutting property owners. And therefore, you cannot take the land of one person to give access to the private property owner behind them, because that would be a taking of private property for private use, and that's unconstitutional. And yet I find that there are a lot of other states that don't seem to find that unconstitutional. And one thing that I don't know is whether in those other states it's required that the right-of-way would have been taken in fee simple. That would make a difference. My opinion here in Maine is that it's a question of if all of the solutions are unconstitutional, you need to pick the one that does the least damage. And that's where I came up with the idea a number of years ago for making it voluntary. Give the landowners a choice. And this was what went through in the 2018 change in the discontinuance law, that landowners are now told, it's up to you. If you can't agree to give each other easement voluntarily, then we have to keep a public easement. We have no other choice because we cannot landlock those people behind you. But if you don't want the public easement, here's an option. You can agree to make it a private easement, and then you'll only have the other landowners using it, and you can have a road association to see that it gets kept in repair. If you can't agree to that, then everybody from anywhere in the world can use that road any way they want, anytime they want. So leave it up to the landowners. And it seems to be working. I do know of at least 2 or 3 situations, just that I know of, where towns are working at getting that done. That kind of thing that I know of at least 3. One thing that might help on that is that it said that the town has to wait a year to allow the landowners to do that. And that could be improved a little bit, I think, if they said they have to wait a year or until the landowners have come up with agreement, whichever is sooner. Because I do know of one situation where the landowners were all ready to do it and the town put it to a vote, but didn't do the vote properly. So they have to scrap the whole process and start over again. And that means they've got to wait another year for the town to send out the notice at the next annual meeting. And then they have a year in which to try to come up with these agreed easements. And they were ready to do it a year ago. So that's one improvement that possibly you might want to look at. We need to look at rights. The public needs to support public use. Or how is there a public need to support the public use on these roads? Well, yes, if the public is using the road, then shouldn't the public be supporting that use? Should they be shifting that responsibility onto the private landowners? Some of the testimony you have, people who wrote in where they're spending $2,000 or $3,000 a year trying to keep up with the public use of the road, and that's not fair to the landowners. especially when they're paying taxes on top of that. Constitutionally, we need to look at the matter of takings of private property for public use, requiring both due process and just compensation. We also have to be careful not to be trying to pass ex post facto law. We also need to look at the question of involuntary servitude. This is one of my husband's arguments from years back, is that essentially this amounts to slavery because these people are being compelled to do a public service with no remuneration for it at all. So those are some things that need to be looked at. Taxes should buy services. One of the things that usually is brought up when we mention this is, well, everybody contributes their taxes to the schools, whether or not they have school children, because everyone benefits from having an educated public. And that's just something that we all do, we all contribute. But the difference is that you're not asking the private landowner who has no children in school to build a school and allow the public to attend that school for free. And that's what you're doing on public easements. You're saying not only are you paying to support the public roads, but on top of that, we're asking you to build another road for the public at your own expense and allow the public to use it any way they want, anytime they want. And that's just not fair. So if we look at taxes, maybe there's some way that we can make a difference there. I had one person who pointed out to me that not everyone contributes to the maintenance of these roads. So do you give a tax abatement to everyone on these roads, or do you specifically make it tied to the amount that someone has put into repairing the road for the public's use? Let's see, limited landowner liability. This is something that Tom Doak has brought up before, that we have laws that limited landowners' liability when that land is used for recreational purposes. Can we also put in something in the law that will limit a landowner's liability when they have maintained a road and the public is using it? As I said, there are questions of what happens if there's an accident, either a collision between someone using the road and an unregistered motor vehicle doing maintenance on the road, or when someone's property or their physical person is damaged because of the condition of the road, which someone has tried to maintain. Another big thing is the enforcement. There needs to be some way to enforce whatever we do. And that's why this bill ended up by the revisor of statutes getting put into sections 3651 and 3652. We had suggested that be for enforcement of what we were proposing, and they decided to just put the bill into that section. Essentially, that gives the county the jurisdiction to enforce having some kind of maintenance on these roads. And as you said, it may be necessary to define what passable means. This is another thing we run into in a lot of situations, is that the definitions are very vague and subject to different interpretation by different people. So one person can say, well, this means there's a public easement for such and such use. Someone else can say, well, no, it's for other use. One of the things that happened in our history on our road is that when the Maine Supreme Court looked at it, they said that a public easement provides unfettered public use. Now, what's unfettered? That means unrestricted. So it means you can't put up a gate, you can't close it in mud season, you can't say that it's seasonal access. You can't even say what kind of public use is to be used on that road. And since that decision went through, we've had people all across the state complaining about these roads being used by ATVs, log skidders, logs being skidded straight down the road. That's a public use, isn't it? We had one case on our road where someone who owned abutting property allowed someone who owned property on the other side of his property to come across his property and use our road to haul the wood out, because it was easier for the woods cutter than going through and using the road on the other side, which was also a discontinued road, but nobody had been maintaining it. It was, again, a discontinued road with a public easement. So if we could define what public use means, that would make a difference. There was a restriction put in on the new abandonment law that will be going into effect shortly that says that it's for use by foot or motor vehicle as defined in another statute, and that definition of motor vehicle would exclude things like ATVs and log skidders. So that's a step in the right direction. One other suggestion that was made to me was that instead of allowing a town to decide what the status of the road is, or an attorney who may or may not be familiar with road law, maybe it would be better to put that in the hands of surveyors. It's their job to know what a road is and to determine the bounds, to determine what the legal status of that road is. And there are a lot of surveyors who do a lot of excellent work tracing down the history of roads, and they're often able to settle disputes just by pinpointing what the actual status of the road is. So that's another resource we might want to look into. If you have any other questions, I'd be happy to go into what specific problems people have had, what the possible solutions would be, what the history of the statutes is, how to trace the legal status of a road, what other states have for statutes. I've been doing this for 40 years, so I have a wealth of information I'm happy to share with you and help answer any questions I possibly can. Thank you.
Thank you, Ms. Manter. Does anyone have any questions for Ms. Manter at this point? You have a list of ideas for us to contemplate, so thank you very much for sharing those. Mr. Doak, you're next on our agenda. If you could introduce yourself and give us some information that might be helpful and helping us determine what the best course forward is.
Thank you, Madam Chair. I'm Tom Doak. I'm the Executive Director of Maine Woodland Owners. We're an organization that works with the family woodland owners in Maine, those people that own a few acres of land up to a few thousand, so the smaller owners. And this is an issue that probably the second or third most common issue that I deal with from landowners around this. I want to start by saying that I really appreciate this. The committee has tackled one of the most difficult situations I've ever seen as far as, and I appreciate the work that this committee has done over the last several years to work at and dealing with this. I have to tell you, there is no automatic or easy answer to this, and there's no perfect solution. So I don't think we go into this saying that this isn't going to solve every problem. And you've heard there's a lot of problems, and I also don't want to blame anybody. This is not, we got in this situation not because somebody wanted to get in this situation. They're well intended, as I've said before, but we're not trying to blame anybody in this. We're trying, how do we limit the damage going forward? And so my comments are kind of meant in that way, and certainly not trying to make a municipality keep a road that they don't want or that they don't need. I think it is important to understand, to remind everybody what the purpose of a public easement was really to allow people to get to the land that they needed to get to, and if that was the only way they could get there. That was the intent of keeping a public easement, to not landlock people. I don't think anybody anticipated that this would balloon into something that everybody uses and everybody, and the landowners are responsible for. So we're kind of in that situation. My one comment on the bill in front of you is it talks about residences, but it's very common that woodland owners who don't have a residence on the property, those easements, public easements, are often the only way to get to their woodland. So it isn't just a residence issue; it's often a woodland owner issue, and those are the issues that I deal with much more than a residence. So it's pretty common that these roads provide access to woodland. I think the idea of a limited public use road, I think that has merit, and I would hope that the committee would kind of investigate that idea, certainly for those roads that have a clear use and a clear need to be maintained as a public easement. I think that has merit to consider. Certainly they shouldn't be this exhaustive road maintenance, standard that is on a regular public highway. And so I would say that is a possible solution to some of the problems. I think eliminating the unnecessary easements. Municipalities, it is correct. Lynn was correct there. Some of these easements came along and nobody even thought about putting them on. They were automatic and they may not have been necessary, but the municipalities have them. If they don't need them, the best thing we could do is eliminate those easements, have the municipalities simply abandon. I don't know if I want to use the word abandonment, that gets used a lot, but get rid of that public easement, and then you solve the problem. One of the real issues is who can use and what uses are possible on these public easements. That's driving a lot of the problems, frankly. If it's a public road, you can't. I'll give you an example. If it's a public highway, you can't ride your snowmobile on it. But once it becomes a public easement, apparently you can. So now the landowner, or you can ride your ATV. Now the main law says the landowner has to grant permission for an ATV. So who's the landowner under a public easement? I think it's the private owner that owns the land. Yet municipalities are granting ATV rights across these public easements across private land, and the landowners are objecting, and the municipalities are saying, we have that right. So a landowner, is there any limit that a landowner can place on a public easement? What rights exist from a landowner? If you could clarify that issue, that would be clear. You did that in the bill you passed last year, going forward on discontinued roads, and said you can only use it for motor vehicles. Lynn will get me if I'm wrong, but motor vehicles and pedestrian traffic, and I believe pedestrian includes bicycles, I think, right? And you can't create a new public easement under the statute other than for that purpose. But now we have this huge void in the middle that says once you create a public easement, all of a sudden the landowner has absolutely no control, no rights. All uses are possible, all uses. We've had people claim they can set traps on the public easement because the landowner can't prevent them from it. So if you can deal with that issue, you're going to solve a whole bunch of problems. I think one of the challenges is there's not been a really direct court case where someone has really challenged, from a landowner point of view, the statute, what rights and what limitations. I think it's clear you can't do a motor vehicle. I think it's clear you can't prevent someone from walking. But also remember, there's no right to leave the public easement. So you're going down the public easement. You may have a right, but the private owner's owned on both sides. So you may never be able to leave the public easement. So that's a real issue. Liability, main liability law, environmental law says if you are the owner of a property and someone creates and there's an environmental violation, you are liable. If you can, and you must fix it. So if you are if you are in fact the owner, you hold all the environmental liability. It says if you can prove that you didn't do it, you don't have to pay a fine, but you must fix the problem. So the landowner is on the hook under environmental law to fix any environmental problems on a public easement. And they have to then prove that they didn't do it, or they'll be fined for this. And that's kind of a weird kind of situation. I think the public liability law, as far as injury, probably does protect the landowner for someone that drives down. The public liability law in Maine says if someone's recreating on your land, you are not liable for their injuries unless you've done something intentional. You've done something that will hurt somebody. You've set a trap, or the example I use, someone has a bridge and they say, well, I'm tired of this. I'm going to saw halfway through all the timbers. The next person driving across is going down through you are liable because you did that knowing that. But the law protects you. You are not liable. And in fact, the law says if you do get sued, when you win, the court must direct the person who sued you to pay your costs. So very, very few cases ever get to a court on the liability issue. But environmental law, the landowners are right on the hook. I think if you can figure out a way to limit who is using it, and I just looked around at a couple local examples, and I don't know if they directly apply or not, but I did 2 places I know around this area. So I looked up the Bicentennial Park in Augusta, which is a town-owned property. and they limit the use of that property and the road that goes into it. And they say that only Augusta residents and their invited guests can use this road and use the property. So they're limiting people, and the non-resident must be accompanied by the resident. So they're limiting that use on a piece of publicly owned property. Reedfield Beach is the other one I looked at, and residents and taxpayers can get a free pass. Everybody else, any non-resident must pay a fee. So there are ways, I would ask the committee look at ways perhaps to limit the people that are using it and somehow get it in a way that discourages people that have no reason to be using this property, these roads. Then you will limit the potential for damage if you do that, and it's limited somewhat to the people that use it, that need to use it. The last thing I'll say is actually one of the bills that was passed, I can't remember which year it was, but there was an inventory. This committee did strongly, it started to direct the municipalities, I believe, to do an inventory. But because it ran up against the mandate, constitutional mandate, it was a strongly worded, we highly recommend you do this inventory. And oh, by the way, you have to report to DOT your findings, and then DOT will report to this committee of the inventory. And I think it was a 2-year, I think that municipalities were given 2 years to do an inventory of old roads and the status. Somewhere that report exists, but not a single municipality actually did their inventory and submitted anything to DOT. I don't know if they did them, but they never sent anything to DOT as the statute required. So the inventory issue is a real issue. I mean, a lot of these are the towns don't know the status, the landowners don't know, and often the town will simply say, we don't know, you'll have to fight, the landowners will have to fight it out themselves, and then we'll figure out what the road status. And that's a difficult one for a lot of landowners. So I guess my kind of summary is that I think if you can find a way to reduce the use by people that have no reason to be on that property and help clarify what uses are allowed in public easement, I think you would go a long way towards solving some of these issues. So with that, I thank you and happy to answer questions.
Thank you, Mr. Doe. Does anyone have a question for Mr. Doe? I appreciate the concrete suggestions. Thank you. Ms. Graham, welcome back to State and Local Government. It's your opportunity to enlighten us about the discontinued roads issue from the MMA's perspective.
Thank you very much, Representative Matlack, and distinguished members of this subcommittee. There's so much to go over, so I was trying to make notes as we were going down through. So first of all, distinguishing what a townway is probably key. So a townway is a public road that a municipality is legally obligated to maintain, as opposed to a public easement, which a municipality may, but is not required to maintain, and a private road, which a municipality cannot legally maintain. The fire protection ability was added for that usually winter maintenance issue with regard to accessing some of the private road because there was questions about expenditures of public funds for that purpose. So that came out of that. At the core of a lot of these issues that have been discussed is how the state approaches the funding of roads and the excess use of local property tax to manage the maintenance of roads. And in many instances, the number of those road miles in each municipality far often outstrip the ability for locally available resources to meet those needs. Since 1991, MMA has provided guidance to municipalities on doing road inventories, and this is voluntary, which allows for municipalities to do this as resources allow, and avoids that significant mandate piece for the expanded activity, which isn't as simple as making a list of known roads in your town. You also have to look at public easements, you have to do deed research. It's quite an extensive process and quite an administrative task. With regard to the ATV issue, that permission authority is provided under Title 12, and that's 13-157A 6 and 5. It authorizes an appropriate governmental unit, i.e. the municipal officers, in the case of municipal roads, to designate a public way as an ATV access route, provided that it doesn't interfere with an extreme right of way, and it may be conducted safely and would not interfere with vehicular traffic. And it requires that it also be posted conspicuously and at regular intervals for that designated access group. Where there's a public easement claim, there's a rebuttable presumption of a permissive use that arises. And in the majority's view of that court case, the public recreational use of unposted fields and woodland has long been considered permissive in Maine, and that was a Supreme Court decision. So asserting that public prescriptive easement piece for recreational uses must therefore affirmatively be proved that it was under a claim of or a right of adverse possession to the owner. It's pretty much a matter of common knowledge that taxpayer dollars can't currently cover Maine's commonly used roads and make them passable, let alone the untold numbers of discontinued ones. And that's the reason why this legislature and the judiciary have consistently established the known precedent of discontinuance process in law, and why that process is not exclusive to landlocking. Current law dictates, as Lynn has noted, that the buyers of property on discontinued roads are often notified that they are not maintained by that municipality at the time of purchase. They're also notified on building permits when they go to require or to get them from communities. And sometimes, this is a matter of personal choice and a buyer regret situation that is really not the problem of the rest of the folks in that community. Municipalities often discontinue roads at the request of abutters who wish to make their road private. And sometimes municipalities do that discontinuance of roads at the call of their citizens who are concerned about the most prudent use of their taxes. At that time of discontinuance that is generated or started by the municipality, damages are paid to those abutting properties for the reduction of value when that act reduces that value. They're also part of that whole process. With regard to taxation, the Maine Constitution requires that all property be assessed equally according to its just fair market value without regard of the public services that may or may not be available. And property on discontinued roads receives a reduced property tax assessment proportional to that change in value when there is at the direction of the Maine Revenue Service, and that who determines assessment standards. So not all property taxpayers on discontinued roadways pay proportionally the same as their neighbors, particularly with regard to the access that those roads provide, which is often to local water bodies, which is another reason why municipalities are often forced to assume easements, which is to maintain the only existing access to a water body within that town that might border upon that town as well. Let's see, what else? Again, so it does receive the ability to have a reduction based upon that if it does reduce the value of that property. And on roads that were discontinued since 1957, towns are often left with no public easement, and therefore they don't have the right to reestablish an easement. Since 1965, the legislature and the judiciary has chosen to incentivize that retention, not discourage it. And then oftentimes that has to do with the only allowable access as a result of neighborhood disputes, particularly when a resident on a roadway has issues with forestry operations that may be may occur on a plot that's further down on those roadways, and related to that damage. However, that particular owner has the right to access their property, and blocking that property is not necessarily a viable option, or blocking that access or restricting that access is an acceptable option, and the neighbors can't come to a agreeable conclusion as to how to manage damages caused by that activity from their neighbors as well. So often the public easement is the last resort to allow those people to continue to access that property, while the neighbors can't seem to sort that out amongst themselves. There's also a new law that relatively new in 2009 that permits municipal repair of a private road if it actually attaches to a watershed or great pond, or if the DEP determined that access is or the roadway is at risk, threatened, or impaired by the road degradation. And there's a water quality tie to that as well. Let's see. Obviously, for a lot of these roads would be considered private roads with the intent. Those are often the ones that folks actually ask the municipality to return because they would like to restrict that access. And the new law for the public purpose for public funds on that private road authorizes only repairs, not maintenance or snow removal. I think that was also covered with the Wyndham case in this past session. It's also probably important to highlight that often the public easement piece interferes with known or existing roads. So in many cases in Aroostook County, roads are closed seasonally for winter maintenance. And that is about the extensive road miles in which those communities must maintain, and the very few numbers of people that they have to pay into that proportionally to their resources. Those roads are really well known by the people that live there. They're communicated, municipal officials notify all the residents on a regular ongoing process, and that also receives extensive public input and review. So as we're looking at the easement piece, and there are a number of ways in which public easements are created and also retained, it's important to think about in ways that might intersect with those that type of activity. I think that's probably about it in terms of the summary that I have in answer to a lot of those questions. I would like to know some specifics that the committee might have. We have such an extensive, massive history on these issues, and I'd be happy to provide a lot of our material, the ways in which we approach easements and the advice that we provide for municipalities, as well as bring in any of the municipality and municipal officials from areas that are identified as problems. I hear a list of problems. It would be really great to have folks in the room that can actually answer those problems so that we have a proportional and full understanding of all of the issues, which are often really complicated.
Thank you very much. Senator Claxton.
Thank you, Madam Chair. A couple questions for Ms. Graham. Thank you for that information. I didn't hear any suggestions as to how to make it easier for the municipal officials to deal with fewer hassles in their communities. Do you have some proposals that you wanted to share with us now or later that might make it easier for elected appointed folks going forward?
Thank you, Senator Claxton, for that. I think that's at the core of why we are trying to retain all available tools that are in that municipal toolbox now, because each one of these issues is so wholly dependent upon the geography, the assets, and the personalities involved in these situations and how well they interact. So the easement piece is often a tool. There's also a process, thankfully now as part of discontinuance, where there is a decision that the town will be making as to whether or not they're going to retain those easements. The process of eliminating those easements, I believe, can be accomplished now as a result of that. And I do believe that a lot of the remedies that folks would like on some of these communities really deal with that one-on-one to municipality. They have the right to actually ask the municipality to maintain that. And towns often do go back on these discontinued roads, particularly as development becomes more prevalent. They do then reopen and make them part of their road inventory for maintenance. So it is kind of a natural progression that happens, but as you'll hear and have heard in a number of those instances, that it's not a uniform solution that is possible because they are all as unique as the folks that are living along the roads and the towns in which they exist as well.
Thank you.
Did you have a further question, sir?
No, I think that's it for right now. Thank you.
Okay, thank you. Representative Toole.
Thank you, Madam Chair, and thank you, Ms. Graham, for your presentation. As with everybody else, you did a great job covering the material. Something that Ms. Manter mentioned earlier about the discontinued law and possibly giving towns and landowners more flexibility to come up with a private easement. Did you, one, have any thoughts on that? And two, have any thoughts on how we could do an inventory that either wouldn't trigger the mandate cost or the mandate preamble, or a way to fund that, or some thoughts around that?
Thank you very much, Representative Toole. I had actually asked Lynn if she might consider, or the committee might consider, bringing in Mr. Coughlin, because there is a pretty extensive local road survey for the roads in which communities receive their funds. And he's also gone in and audited some communities and found that while maybe roads had changed, the road miles hadn't. So there wasn't a proportional change. It essentially was a road mile maintenance issue, and whether or not those discontinued roads had existed in his list versus what new roads had been created or expanded roads for access. There wasn't any change for road miles within those communities. So he already has like a very large list of those towns. What they don't have is the list of discontinued and abandoned roads, previously abandoned roads that I think, requires extensive deed research, because just because someone says it's abandoned doesn't necessarily mean that it has been, which is why we have such extensive road cases through the court system. It's a laborious process to go and determine.
No, and I understand that. I was just thinking, it would be great to have it. I don't know how we can get there with obviously it would take 2/3 to require something like that. And I'm not suggesting that we don't even know what the price tag would be. So it'd be hard necessarily to support that without knowing what the price tag would be, or without helping municipalities that don't have the resources do something like that. So please don't take it as support for that. But I think it might be something to look at and kind of try to maybe get our arms about. But again, the other part was Ms. Manter had suggested that, maybe we could come up with, allow towns more flexibility to give folks more time to come up with a private easement for their road, instead of having to start over again and start the whole bureaucratic process over again. Is that something you could be on board with? And beyond that too, the education component when people buy a property or build on a property, is that required that they have to be notified that it's on a discontinued or abandoned road? And if not, what are your thoughts on making that the case?
Thank you very much for that. A couple of things maybe I can provide what MMA provides for guidance on doing a road inventory to municipalities, so you can see as what that would entail. And also with regard to extending time to come to a private easement agreement, I believe that there will probably still be situations where there's not going to be agreement in those cases. So time might be a problem, but might be able to be expanded. But I think that, there also needs to be some sort of remedy for when they can't, which I think will end up being a very frequent outcome of that situation.
Right.
And yes, particularly in towns where there are a number of folks that live, or a historic issue. I think as it was in the 129th, folks in Glenburn, I believe, came in and complained that the municipality hadn't been doing its job, when in fact, every single one of them was aware, and it's actually noted on the code, on the building permits, that this is not a maintained road. And it really came about as folks who had bought property were reliant on one individual who ended up passing away and had the tractor. So there was no desire to continue that maintenance. And I think that that's an enormous problem. I'm not sure how much education municipalities can do preemptively, but I know that they do extensively do that. And I do believe that it is also required on the purchase and sale agreement for the individuals to be notified.
And is it with respect to the building permit?
On the building permit, that was something I believe that was voluntary that community did. And you do find that in areas, in communities where they have some historic issues with these private roads. And that is also the reason why they created the law, or they passed the law in the judiciary that would require those individuals to buy into that and allow them to actually put a lien against property for individuals who weren't buying into that process as well.
But that's something that could be achieved, as Ms. Manor had suggested, also with the if people come to an agreement before the year is up on a discontinued road, on an easement, that's something that we could change and maybe do some small tweaks that could help some folks. Would you agree with that or not? Or any thoughts there?
I think anything that would help enable them to come into an agreement and recognize that common access piece, so that they could remove that. I just know that in some cases, for instance, the Great Pond case, that would be an extreme challenge that, if it were to be generated by those folks, there might be some intersection there that might interact with that particular removal of public easement. But largely, any time in which they can revert fully, that would be great. That they wouldn't have to retain these in order to make sure that folks were able to access their property.
I get you. Thank you very much.
Thank you. Senator Claxton. I should also mention that we're asking Mr. Coughlin to come in and chat with us this morning. Senator Claxton.
I just wanted to add one thing to what Representative Toole said, that in addition to education around whether the road is abandoned or discontinued, you'd also need to include the issue or the information about whether there's a public easement or not. And then a definition of how that would potentially impact the property holder. I think anything short of that isn't informed. And then the other question I had was has private access or reaching agreement on private access been successful in protecting these roads so that they're not chewed up? Does putting up a sign that said this is a private road, does that doesn't limit the logging truck if they've contributed to the costs for the maintenance of that road and they signed on as a private owner, doesn't limit them from driving back and forth. And there's also the question of what constitutes access. If I can get to the property, is that the same thing as being able to haul out thousands of pounds of log down that road? So there's some issues to be addressed there.
Thank you, Senator Claxton. I do know that, just that would fall into the destruction of a public easement. And I know that there have been instances quite locally where both the town and a logging contractor have tried to work with the abutters to repair that road and to provide that access. And again, they would still have the right to be able to post that for weight limits during certain times of year based on the same type of standards that municipal officials have currently as well. And you know, if you're damaging that, regardless, that's still not permissible. So I think that there is an obligation for those folks.
Thank you.
Thank you. Ms. Manter, did you have a question for Ms. Graham?
I actually wanted to provide a couple of answers if I could to some of the questions that were raised. That question that Senator Claxton just had about what happens if a logger is one of the private landowners who have agreed to having a private easement. I think the answer to that would be that once it's a private easement, you could have a road association that would then be coping with just the issues of the private landowners and not having to also cope with private use of private funds to maintain a public road. So if there's a road association set up on it, it could include in its bylaws that if one landowner damages the road, that they are responsible for repairing the damage, restoring the road to what it had been. So I think that would be the way to handle that. And also Senator Claxton touched on the question of defining what is meant by a discontinued road or a public easement. And that was one thing that I was going to mention before he brought it up, that just because there is a disclosure when a property is sold doesn't mean the person really understands what that means. If you tell a buyer, oh yeah, that road is a public easement, well, you've covered your obligation. You have told them the exact status of the road and that it's not maintained by the public. But that doesn't necessarily make them aware that everybody is going to be able to use it any way they want, and that they're then going to be left to the bill repairing the road because the public isn't going to, yet the public has the use of that road. So I think defining that would be an excellent addition to the law. As far as making agreements to extinguish a public easement by establishing private easements, my concern that I brought up was that if the landowners have come to an agreement before that year, can we allow the process to go forward sooner? But is also the point that was mentioned that what if they can't come to an agreement within that time limit? Well, I think the answer to that would be that Section 3026A would allow them to propose to the town at any time that they have come to agreements and they would like to try again to discontinue that public easement. So I think if a longer time is needed, that would be the answer. If a shorter time is needed, and that might kick in these cases where they weren't able to do it within the time limit. Say 6 months after the time limit ran out, they are then able to come to an agreement, then they should be able to go forward with that and not have to wait another year to get that done. Thank you.
Thank you. Good morning, Mr. Coughlin, and welcome to our subcommittee meeting. My apologies for not inviting you in sooner. If you could please introduce yourself to us, and I know you've been listening in. If you have any comments that you'd like to share with us, I would appreciate that. Thank you.
Okay, sure. Can you hear me okay?
Yes, we can.
Okay, good. Yeah, I'm in the office here today and I was just going to sit and listen, but things change on moment's notice. So thank you for being allowed to be in front of the committee, and hi, Roberta, Rebecca, and Tom. I've been working for DOT for 44 years, and the last 25, I've been involved with local road assistance and inventory of all local roads, because in order to pay every town local road assistance money, we need to have an updated, accurate inventory of local roads. And I'm still pretty active in doing that. That's just one hat that I wear here. But for instance, last week I did 2 road inventories. The week before I did 2 others because I was in that part of the state. And I meet with the road commissioner or the selectman or the town manager or administrator, and we go through every single road. And I'm looking for just public roads, because local road assistance is just based on local road mileage. I work very closely with the 911 office, and whether it's Erica or Tom or the other fellow over there, they maintain the entire database for public and private roads. It's basically wherever someone lives or there's a business, they need to know the roads. So they keep track of all of the private roads. And then we work together to maintain the public road inventory. So for instance, last week, when I went down to 2 towns down on the Blue Hill Peninsula, I write up something like this.
Oh, can't see it. There we go. There we are.
And,
Okay.
and that's just the changes. For instance, last week when I did these 2 towns, I had about 6 changes. Sometimes I have a page and a half. Sometimes it's 2 pages of changes, because most of these roads really haven't been reviewed in at least 10 years. The department used to, about on a 4-year cycle, up until 2009, we used to review 1/4 of the towns per year. So we'd send them a map, or we'd have a staff person go down to the town over the winter and go through the map and update everything. That stopped back in 2009 because I started working directly with the 911 office so that we did this together, because why should we have DOT doing it and 911 office doing it when we could both do it as 2 state agencies helping each other? And that's worked very well. So the way it works now is addressing officers in every town. For instance, I'm an addressing officer in 2 towns. Whenever an addressing officer has a change, such as a road goes from private to public, a new subdivision is built, a road name is changed, or whatever happens, it's up to the addressing officer to contact the 911 office. And if there's any changes there relative to a public road, that's when they send me information and I update the DOT inventory. And it looks like my video is popping in and out, but is the audio okay?
Yes, the audio is okay. I think you're fading into your background upon occasion. Now you're on mute.
Yeah,
There we
okay.
go. There we go.
So we're in a regular routine. We review road inventories across the state. For instance, probably, I haven't added this up lately, but I'm going to guess that in the last 3 years, we've probably done 150 road inventories where I've sat down with a road commissioner or a selectman or someone, and we go through every single public road. And I usually come back. In fact, there hasn't been one, well, there's only been 1 town where I came back with no changes. Most towns I can come back with many or a page worth. And most of those, for instance, last week when I did these, the longest road that I took off the inventory was about 3/4 of a mile. And this is a typical comment I get. Oh, geez, we haven't maintained that road for like 20 years. Okay, so we're going to change that. But most of the time it's a couple 100 feet here, a couple 100 feet there. And sometimes we add roads that no one has contacted us about or hasn't notified 911. But it's a very collaborative process, and it's to benefit the town and 911 and DOT to make sure that local road assistance money is paid as accurately as we can. So I think I'll stop right there and see if anyone's got any questions.
Thank you very much, sir. I'm wondering if we probably should have asked somebody from E911 or EMS to come and chat with us about their private road lists, seeing as it looks like they might have a better handle on what the private roads are in the state.
Yeah,
so that might be on our to-do list.
One other thing I'll add is when I go to a town, I bring this big map with me. You can't see it right here, but it's a big map, and the map combines the DOT data and the 911 data. So it shows all roads in a town that are public or private. And when I do the review, I'm just concerned about the public ones. But we do have information, and yes, the road inventory for any given town, I can produce with a push of a button, and it lists every road, name, length, intersection from and to. So I've got all that information because we have to. That's what drives local road assistance.
Thank you. Representative Toole.
Thank you, Madam Chair, and thank you, sir. I think you came to East Machias a couple of years ago now, as I remember.
I certainly did, Will, and I
Yeah.
think Bucket was there at the same time, and we did
Yeah.
exactly what I just described.
Yes, exactly. And I appreciate you coming and presenting or working at that time. It was a very thorough job. What I would ask though is how much work would it be to add another field into a database or whatever you have if it's, well, first, is it all electronic, digital? And
Yes.
second, with that, is it, how hard would it be to add in whether there's a public easement, private, how hard would that be to add that information in?
So one thing I need to make sure I explain here is that when I do these reviews and with these maps and with my inventory list, I always start off by saying, look, I need to know what you maintain. I'm not here to determine the legal status of something you maintain or you don't. That's not my purpose. But I'm going to assume here that whatever you maintain is indeed a public town way or a public easement, because that's why you're maintaining it. So it's really my list and my maps are of what they maintain, because that's what the local road assistance law is based on, maintenance. If I ever tried to get into the legal side of which is a town way and a public easement, sure, I could do that, Will, but I'm just not sure that, some people have a good handle on this. And because of the turnover in towns, some towns, the new select person, the new road commissioner, they don't really know in a lot of cases because there's a lot of turnover.
Right, and I understand that, but with that, does E911 do that sort of thing for the roads that they keep track of?
No, they don't get it down to the, I mean, I can go into the 911 database and I can see if it's listed as public or private, but they don't really focus on the accuracy of that because they're more concerned about the name of the road, its location, and where people live. And there's little dots on the map of every house. And many times I found that the actual legal status listed in the 911 system is not the most accurate in the world because it's not a high priority for them to keep track of that stuff.
Thank you for that, and I think that does raise a lot of questions. I don't know how we address the issue, but it does raise, it seems like that trying to sort out legal status, if it's at all possible, and I know it's labor intensive and it may not be possible, but it seems like that has to be a part of any large scale solution. If we're not going to be able to do that, then we're probably going to wind up with a smaller solution.
Yeah, I mean, I can certainly, going forward here, I could ask if they could specify if they know if it's an easement or a town way. And we'd have some sort of accuracy there. I'm just not sure it would be 100%, but it'd be better than maybe what we have now.
Okay. Thank you very much.
Sure.
Any further questions for Mr. Coughlin? Okay. Going forward. All right. So we have heard from a number of people this morning. Thank you very much for all of your input. Where should we go from here? Do we want to meet again and come back? Do we want to talk about questions we have at this point and then ask Lynn to come back with information? or other people that might be able to provide the information, and discuss what we seem to feel would be a resolution to this, or at least the beginning of a resolution for this issue. Representative Toole.
Well, thank you, Madam Chair. I think first off, I think when we do come back, I think generally we all should, maybe today, maybe not today, if folks just want to process what they've heard. But I think when we do meet again, and I definitely think we should all have a general idea of what we agree upon and go from there. And I think what I've heard to this point, I haven't, and Representative Copeland hasn't weighed in, or Representative Downs, but I think if everyone is in agreement that we try to resolve the whole issue of giving people more flexibility in the public and in the whole public easement process, and whether to pursue a private easement, if that's something we can agree on, I think at the very least we could do that. I mean, I am interested in finding out more about the inventory, and not so much to mandate towns to do it, but there is a vested interest in the state having it, and it would be nice to see what that would cost and what kind of a rabbit hole that could trigger, and if we may be able to make a pitch for some funding there. I'm not saying we should, but it might be worth looking into. That's just me.
Okay. Senator Claxton.
Yeah, for me, big picture would be to end up with some sort of solution that would keep us from digging this hole deeper than we're currently doing on a day-to-day basis, hour by hour. And the other piece I'd love to accomplish would be something to rectify some of the issues that are still out there. And I don't think I would ever use the term solution and discontinued roads in the same sentence. I think we're looking to find a couple of loose ends to pull on this huge knot. And if we can be successful in that, then I will consider this a productive engagement. For me, so far, I'd like to see if we couldn't come up with a way to promote progression to private roads. I think that would be a help. I think understanding, for me, I don't understand whether that comes only from the owners or whether it could come from the town in terms of facilitating, but anything we can do to promote changing from general access to private access would be helpful. I do like the idea of improving our definitions. I'd also like to entertain the possibility of how to promote discontinuing easement. That's really what I was thinking of in terms of the owners versus the town. And if we made a law, for instance, off the top of my head, that towns are responsible to maintain any road for which there's an easement, there will be a significant incentive to get rid of some of the easements that we have that aren't serving our people well. So I understand we're trying to untangle issues. I'm having PTSD from about 2 years ago when I felt overwhelmed by a similar conversation and how tangled this is since the Kings Highway was put in. But so that's another thought, and I agree with Representative Toole that some further consideration of inventory and how best to get to a worthwhile list would be a good use of time. The question is whether it's a good use of enough money to support that work. So those are my thoughts right now. Thank you.
Thank you. Representative Copeland.
Thank you, Madam Chair. This has been a very good conversation. There's so much information in the courts and through different laws, and it's very complicated. I also think of paper streets as part of this conversation, and it's a lot. And I think there are unintended consequences everywhere. But I do think that we can work toward getting, we have to consider all these different uses, snowmobilers. I mean, of course, in Maine, we want people to recreate. But we don't want private citizens having to pay to maintain roads that others use. That's just bizarre. But then we also can't force municipalities to do it. So we have to come up with some really creative things. I agree with Senator Claxton that we have to try and discontinuing roads because it's just a heartache there. And I'm not sure how a discontinued road could be made public. I mean, there has to be a transfer of money. I mean, I don't know how that would work. And I think there's a lot of prongs on that one. I think defining a lot of these things that we talked about, like what is passable, what's a public easement. I mean, there's just so many things to define. Limited use. There's so much out here. And liability, the environmental liability, there's all kinds of things out here. I think we need to, just really think about it. I'm wondering if we couldn't have an attorney. I don't know if who has been in active litigation on this. Both sides of the story. Maybe we could hear from them from what they have, their perspective from both sides there, because they're in the courts and they're working with the laws that we already have. I know that there's briefs out there online that you could read until the cows come home. And I am curious, are there, for discontinued roads, what makes up a discontinued road? Are there size requirements? Are there minimums or maximums? Nothing. I'm seeing Peter say nothing. There's no restrictions, nothing. Because I was thinking maybe a sharing of the road partitioned off for access to homes, but I guess that's not even possible. And I was wondering if Mr. Coughlin has that information digitally, if it could be posted online somewhere so we could paw through that.
Coughlin?
Yeah, so the inventory that I have is on the department's internal databases. And I would have to talk to the IT people to see. I'm sure it can be done. It might take some time. I don't know where it sits in the whole priorities of stuff, but I can at least ask if those inventories can be put on there, because it's really just a matter of taking an Excel spreadsheet here and posting it on there, and it's arranged in the state highway, state aid, townway, and any seasonal roads that are maintained. So it's just a spreadsheet. It's just a matter of putting up 485 municipalities, 3 Indian townships, and 10 counties.
Okay, sounds too much. We don't spend that kind of money.
Are you looking for a total, or are you looking for just an example of the information that's stored by DOT and 911?
An example of the information.
There we go. There we go.
Oh, sure. Yeah, I mean,
Perfect.
I can send that to the committee if you want, or send it to Lynn and she could get it out there.
Please, yes, just an idea of what sort of data the state keeps, and both you and 911 would be great.
So what I was going to offer was, if you want, I can work with my partners over to 911 at the PUC and just sit down with them and get into a little more of the weeds, exactly what they maintain, and see how our two systems jive, and then I can report back to what we got.
Perfect. That would answer a lot of questions, and
Okay.
have you being the person that provides state information for us.
Okay, just need a timeline, that's all.
Thank you. Okay, questions answered, Representative Copeland?
Yes, ma'am. And I definitely think that we should continue on with these conversations, because leaving it alone is really not an option to me.
Oh, no, I think we're going to have we're allowed to have a total of 3 meetings. I know we will have at least a second meeting and perhaps accumulating information between now and then coming back ready to discuss and refine the information that we have is what we're looking forward to. Representative Downs.
Thank you. I really don't have any information to add because I agree with what everybody has been said. And I do want to come to a solution like everybody else. So the more information we can gather, we can come to a great understanding and work towards a solution. So,
Right. I think we're beginning to see where the gaps are.
yes.
And it's a question of how do we fill those gaps? How do we answer some of these questions? And if they're totally unsolvable, that is what it is.
Yes.
Yeah.
Great. Thank you.
Ms. Graham?
Thank you, Representative Matlack. I just wanted to add that I provided Lynn a snapshot of all the ways in which easements are created and what types of easements that they are. And some of those easements are non-voluntary. For instance, if they are accessing a cemetery or a great pond, or again, that protecting abutter access because there isn't an ability for them to come to an agreement. So I just want to caution that as you're parsing this out, that you look at, non-voluntary reasons why municipalities have kept and or retained those easements. And also I just wanted to notify you that we are in the process of sending out a pretty comprehensive survey to municipal officials. And embedded in that are going to be a number of questions, particularly regarding public easements, whether or not the town is aware if they've retained any public easements as part of discontinuance, if they are, and the reasons for that, like access to a historic cemetery or great pond, what types of complaints they're receiving from folks and how they're addressing those, particularly around excess weight vehicles, large gatherings that may be impromptu on some of those as well. And whether or not they use those public easements for, municipal reasons as well, like some sort of event, and some of their opinions around the whole process and how that might affect them in this process. So that will be going out, I believe it might be going out this week. Yeah, it'll be going out this week actually. So it'll be due back around October 5th, I believe.
Okay. We are allowed to meet, I think, up until the beginning of December. So we're allowed to meet October, November. Do you think your data might be available prior to that, or?
Yes, absolutely, because there are a number of other, unfortunately, stakeholder meetings that MMA staff are buried in. So we're asking all kinds of questions, but we did already preemptively add in stuff about municipal roads with public easements and maintenance and everything that can be covered in this particular committee, hopefully.
Perfect. Yes, that'd be great. Ms. Manter.
Yes, going back to the question of the inventory, the proposal that I had offered before, I was hoping would be a way to take a lot of the burden off of the municipality by putting it in the hands of the landowners to say, wait a minute, we think there's a problem with this road. And that would also mean that any road that nobody brings up a complaint about, those would just automatically be gone at the end of the process. So that would eliminate a lot of the roads. And hopefully it would provide a mechanism for kind of taking it down into bite-sized pieces instead of leaving the town trying to figure out the whole thing. I also, where Pete Coughlin was talking about, what information is online or is not online, they do have the DOT public map viewer, which if you know how to use the layers on it, you can get a lot of really useful information as to the status of roads there. It will even tell you, if you know which layers to bring up, it will tell you if a road was at one time a county road that was discontinued, and we'll give you the exact page number to find that discontinuance so you can read the actual language on it, which will help determine whether or not there is a public easement on it. But I do agree with Senator Claxton that this is a big knot that we have to untangle. And being someone who has had long hair for years and who has had horses with long hair for years, one thing I've discovered about knots is that if you try to attack the whole thing at once, you just make more of a knot. But if you pick at the edges and you keep pulling out the little threads that are not actually tangled too much in the main knot, by the time you've pulled out all the little threads, all you have left is a little teeny tiny knot that maybe you'll just have to cut out. But I think that's what we've been doing for years, is picking away at the edges of the problem, and hopefully we'll get the
Some of us
problem
have
down
done
to a small piece that we can deal with. As my husband says, some of us are tired of waiting. It has been 50 years for him, and there are a lot of other people out there who've been patiently or impatiently waiting for us to solve this. So hopefully we can move forward and get a little bit more of this knot untangled. Thank you.
Thank you. Mr. Doak.
Thank you, Madam Chair. There are definitely two sides to this issue. I'm not blaming municipalities, and they've been given a difficult situation, and landowners are in a difficult situation. So, there's plenty here on both sides. But here's the frustration. I guess I could sum up the frustration from a landowner view in three ways. They go from you go from a public road, which you don't have any, you just use. But when a public easement occurs, you end up with all the responsibility, all the liability, and no control. And those three things added together make this hugely complicated and frustrating thing from a landowner. They have no control but all the responsibility and liability. And that's the crux, frankly, of the real frustration that landowners have and people that have to use these roads. So if you can deal with any of those three some way, that would ease the tension, at least on these issues.
Thank you, sir. Representative Toole.
Thank you, Madam Chair. And I do think that, as I say, I do think there's opportunities. I think Mr. Coughlin and Ms. Graham both will have some information by the time we meet again. I'm hoping that it will be sometime, I'm going to be gone middle of October, but hopefully by the end of the month, that'll all be synthesized or put into some kind of a format that we can all process and lead us forward, because there are opportunities here. And Miss Manter's right, picking at a few threads here and a few threads there eventually. And I know it isn't going to be as fast as anybody would like, but something like this you have to be very careful and thoughtful and methodical about. So that's all I would add.
Thank you, sir. And Senator Claxton.
Thank you, Representative Matlack. I guess I'd like to make sure that we made an effort to focus on the biggest solvable problems. That's hard to define in both of those adjectives. But I don't want to fix the rare occurrence issue. I want to address some of the more common ones, and that may be a list from different participants about what they see as the biggest issue. And if Ms. Matter has some follow-up on the Vermont inventory in terms of outcome, I'd love to hear about that at some point. Thank you.
Thank you. Mr. Coughlin.
Yeah, just one more quick comment. And Rebecca, this might help you too. About 5 years ago, I think we changed the statute to say that when a town went through the discontinuance process and all those steps that are laid out very well in the MMA roads manual and in the statute, we added that the order of discontinuance shall be filed with DOT Maintenance and Operations Office here in Augusta. That's the only way that I heard about the change in status of a road without me actually doing an inventory. So how many have come in the last 5 years? I can probably count on one hand. I'm thinking there were probably 3 or 4 actual discontinuance notices that have come into me in the last 5 years. If that's an indication of how many active discontinuances have occurred in 5 years, I don't know. But most town officials, they follow the steps that are laid out, and it does say send a copy to the registry and send a copy to DOT. But I just haven't received that many. So Rebecca, that might help you a little bit.
Ms. Manter.
Yes, one thing I do know is that there's one town that had abandoned a road and didn't file it with the Registry of Deeds until several years later. And I don't think that they also filed it with the DOT. So that may be part of what's going on. Getting back to the information that the DOT has, Pete Coughlin, maybe you could tell me on this. If it's a matter of getting permission to post it online, that's one thing. But if it's a matter of the labor that's involved, I would be willing to come down and use my little magic wand scanner and scan those into digital for you. So that would be helpful. I would love to have that available online so that I could look at it when somebody comes in with a question about a road.
Geez, Roberta, you said you already had a full-time job doing this. What do you want to do? Not sleep at night?
I already don't sleep at night sometimes, so what's the difference?
Thank you.
All right.
And the other thing I was going to mention is that with regard to the Vermont inventory, I know when they first passed the law, there was a great uproar about how towns were going to accomplish this. And one of the things they did was to recruit volunteers to go out and just comb the countryside for roads. And that also made a lot of problems because a lot of these volunteers really didn't know what they were doing. And if they saw anything that resembled a road, they would report it. And lots of times these were just woods roads that never had been public. And in at least one case that I know of, they found a road that was going through the middle of a house. But I think things have kind of quieted down there. They've pretty much finished the process and have categorized all the roads. And the ones that were not categorized were automatically extinguished. So I think it was a successful project in the long run. It had some snags along the way, but I think the eventual outcome was pretty successful.
If you could share a link so that we could look at that, that would be very helpful. If you could send it to Lynn, she could include it in our information.
I'll see what I can find. I know there were a couple of newspaper articles on it. I don't have any actual link off the top of my head to the inventory itself, but I'll see what
that'll be fine. That at least gives us a place to start to look for more information if you have an article or two.
Okay.
Perfect. Thanks very much. Well, are there any other bits of information we need? Do we want to talk now about when we're going to meet again, or shall we ask Lynn to sort of ask around and do a Google Doc, or do you want Senator Claxton?
I was just going to say I'm fine with Google Docs, and I'm trying to plan my life a little bit between here and the expiration of this subcommittee. So if we could try for 2 dates, knowing we can cancel the third if we don't need it, I think that would be helpful to me personally. But thank you.
Thank you. Representative Toole.
Yeah, and I would add anything after October 20th is fine with me. So, and I think that would give folks time to compile information and to process all they've heard today. And the third meeting, I mean, worst comes to worst, if we don't finish in a third meeting, we still have the opportunity to meet once we're back in session without permission of the, no, I don't mean that way, but without having to ask for extra meetings, we would have the opportunity to do once we're back in session.
Okay. So, Lynn, if you could poll the folks here and see when we might be available after the 20th, because Representative Toole's going to be gone for a couple of weeks ahead of that. So that would be great. Otherwise, if we're all in agreement, I look forward to seeing you folks again in about a month or so. Terrific. Have a good day.